tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
I think it's fair to say there are good lawyers and there are bad lawyers. Thankfully, the latter is somewhere else and the former is here. It's a very long-winded way of saying it's terrific to see David Whiting, Melbourne solicitor, in the studio.
Thank you.
If you missed that, you're one of the good ones.
Oh, okay. I thought we were going somewhere. I wasn't sure where.
That's the whole show, mate. 1300 222 774. You got some homework?
I got homework and a correction.
Okay, please.
The homework was I got a caller from Brunswick, and the issue that he had was that he has rented commercial premises with accommodation at the back. He has the lease from the landlord. He has sublet to someone at the back. And the question was, does he have any different rights to residential under the residential tenancies legislation than if he was the landlord? Now, there's two answers. The landlord could terminate the lease and that would terminate the residential portion of it. But I can't imagine that the landlord's going to want to do that because the tenant probably doesn't have the right to sublet without permission. But otherwise, it's treated as a standard residential tenancy. He needs to give appropriate notice, which is at least 60 days. There are requirements in the legislation as to what he produces, but one of the reasons can be a desire to resume the property for business purposes. So I'm going to use the flat at the back for storage, for example. So that's his question. And then we had a lady last week calling about her son who had bought a property and hadn't yet sold his other one. And the question was, what was the capital gains tax consequences? And I got corrected during the week from a listener who sent me an email that said you can have a 6-month overlap. So it's possible to claim the principal place of exemption on two properties when you're moving from one to the other. So the relevant date is the sale dates, not the settlement dates. So if you were to buy before you sell and the period is less than 6 months, you're okay.
Okay.
Thank you.
Yesterday, if you don't mind, before we get to calls, 1300 222 774, David Whiting is here to take your calls. But yesterday I spoke with Evram Shen. She lives in a tiny little house. And the Yarra Ranges Council are saying that she needs to demolish it.
So we built a tiny house on wheels that's classified as a caravan, and we were living in the Yarra Ranges in Belgrave South for the last almost 3 years on private property. We got a call and we were told that, no, actually, you're a building. You have to get a building permit or leave. They're telling us that we have to demolish the house or leave.
Okay. So the council told us that it's because there's new laws around having a second house on your property that requires a building and planning permit and a surveyor. What's your call on this, Dave?
Well, I think the starting point, my view would be you're not demolishing anything. If anything, you're trailering it away. I suppose the question needs to be, so is it a second? It's kind of like a caravan is the way that what I got from the call. We built a house on wheels, which means that it's movable, and I would have thought would have been treated as a caravan. But if it's been plumbed in, so, the toilet's connected and the sewer's connected and the water's connected and electricity's connected, maybe then what you're then doing is under the planning scheme you are constituting as a house. And if there is a second residence, yes, you do need a permit. But there have also been some recent changes in relation to allowing second residences, but that's in residential zones. And if you're in the Macedon Ranges, it's possible that you might be on a larger parcel of land. So, yes, you probably do need a planning permit, and if it's plumbed in and wired in and got the water's there, then I would say, probably does meet the requirements for a second house.
1300 222 774. Loris is in Bentley. Hello, Loris.
Good morning. David, my husband died last April and his will leaves everything to me and I am the executor. Am I legally obliged to change our home title into just my name?
No.
Right.
But you may, the situation is presumably you own the property jointly.
Yes.
Then the property can be transferred into your name, or transmitted. So you lodge a survivorship application. The property's in your name. Are you required by law to do it? The answer is no.
Right. And if I don't, would that have any ramifications for the ultimate sale of the home?
You mean by you or by somebody else when you pass on,
by my
Loris?
children at my death.
At that stage, they will have to do what you're now not doing.
Right.
So it will need to be done.
Right.
And I had one across my desk yesterday where the husband died in 2017 and the wife died earlier this year, and we've got exactly that same issue. So
Right.
it's taken 8 years, and now we're doing the survivorship application, but as part of transferring it to the executors.
Loris, thank you very much for the call. Rosemary's in Blackburn. Hello, Rosemary.
Good morning. How you going?
We're great. We've got you.
Good.
What's your question?
Last week there was a judgment made by Mr. Woodward as the president of VCAT with regard to deferred management fees.
Yeah, that's Justice Woodward from the Supreme Court, who's the president of VCAT. Yep.
Yes. Now, I had a case before VCAT last year with regard to a deferred management fee, and the solicitor at the time talked me out of proceeding with the case because he wasn't sure what VCAT would do about it and whether, in fact, they would uphold the law. Now, my question is, I want to proceed with this and see what I can do about recovery.
How did the case come to an end at VCAT, Rosemary? How did your case come to an end?
It came to an end by agreeing to a settlement that wasn't what I wanted.
Okay, well then the answer would be no, right?
Okay.
You can't go back to VCAT. If you had been allowed to withdraw your claim with no order as to costs and without an adjudication on the merits, you could start again. But if you've actually reached a settlement, then the proceeding's gone away. You can't do it again.
Okay, another question, very quick.
Yep.
There's 190 residents in the village where I was living, and they all want to go ahead with this. How do we proceed with something like that?
Well, you could, as a class action, all engage the same law firm to take on the case. That's probably where I would start. But in each case, though, of like that, it all depends upon the representations that were made to the resident. And it may be that there is not sufficient uniformity in the number of residences that you're talking about. So it might be a class action for some but not for all. So there are firms that do class actions. Have a look at one of those.
Rosemary, thank you. Sam's in Watsonia. Hello, Sam.
Good morning, David and Justin. Thanks for taking my call. I've just got a situation with an elderly mum. Dad passed away back in 2022. I've got a sister who's been interstate for 20 years. Back when, in 2012, Mum and Dad made a joint will, giving me financial power of attorney when the time came, and joint executors.
Can we get the language quite right? You don't appoint a power of attorney by a will. So did you get a power of attorney?
Yeah.
Okay, yeah, and that was just to you.
Yes,
and the
correct,
executorship is to you and your sister when your mum passes away.
Correct.
Yep.
So in 2021, Mum was diagnosed with dementia, hospitalised for 6 weeks, all that sort of stuff. She came home with an aged care package, so we organised nurses, or I organised nurses to come and visit, all that sort of stuff, to look after medication, that sort of thing.
Sam, what's the problem?
The problem is we regularly check in with the nurses to see how Mum's going. 6 weeks ago, the nurses put me through to their manager, who said they can no longer talk to me because the will has been changed. I'm no longer a financial power of attorney or next of kin. So I was obviously pretty shocked. I rang the solicitor where I know the will and a financial attorney is, and they said, no, as far as they know, it's all still, valid, and they actually sent me...
Sam, go back to the care provider
Yes.
and ask for a copy. Now, what happens is the appointment of a new attorney revokes the earlier one, right? So what you need to do is, I would be saying to the care provider, I can't be satisfied that I've been fired until I see the new one. So it would have been possible for your mum to terminate your power of attorney. I'll come back to the dementia in a minute. So, but there's no evidence that she's done that. The law says that the appointment of a new attorney revokes your appointment. But I would be saying to the care provider, I need a copy of the power of attorney to be satisfied that I've been fired.
So what happened is I rang the legal firm and they said, oh, no. And then,
No, I understand. So if there is a new document, it's not been prepared by that firm. It's been prepared by another one.
This is the thing. Then, so they sent me the verified copy to say, so I know it's all still valid. This is like 6 weeks ago. About 2 weeks after that, they ring me and say, oh, actually, we've found another will packet. Mum came in with the neighbour and changed the will in December 2023. And
Sam, are we talking about the will or the power of attorney? Let's ignore the will. Your mum's alive.
Okay. Yep. So the power of attorney.
Yep. Then there is a new power of attorney and your one's gone. Yes. Yep.
So my question is, I guess we're obviously worried that mum's been influenced by a neighbour and my sister who hasn't been around for the last 20 years. And what can we do? Like they won't talk to us anymore. Mum still talks, and I go over and see her, whenever I can. So I think we live about an hour and a half away, so it's a bit of a journey.
Sam, do you think that your mother had capacity when do you know the date of the new document?
I do. I know the month.
And that sounds like something like 3 years after she was assessed with dementia?
Correct.
Then you could challenge the power of attorney at VCAT on the basis that mum had dementia at the time?
Yep.
If that's what you want to do.
Yeah.
Sam?
So that what you're putting to me is that it wasn't your mother's will to prepare the power of attorney. What you then do is you then say, you go to VCAT and you challenge it on the basis and seek to be appointed as the administrator. Thank you, Sam.
It's 10:18. Justin Smith filling in for Raph Epstein for a few weeks. We're here with David Whiting, my lawyer, your lawyer, everyone's lawyer. 1300 222 774. David Whiting is here taking your calls. Kate's in Armidale. Hello, Kate.
Hi, Justin. David, if I could have your time briefly, just in relation to a parking incident that happened wherein I was driving into a car park and going up, and one of the car park aisles, I went to indicate that I was about to reverse. I then saw out of the corner of my eye there was a car reversing, and I thought, hang on a minute, if we're both going to reverse, one of us is going to hit each other. I then put on my horn, indicating that, if you continue to reverse, you're going to hit my car. Shall I keep going?
Okay. David, I'm sorry, we've got you now. I apologise.
That's all right. Kate, you still there?
Yeah.
Okay, so what we've got is a single car parking bay where people can approach from different aisles in, let's call it the supermarket car park. And you were going to back in and you find that someone's backing in from the other side. Is that right?
No, I was heading in towards the park to my right, nose in first, and then just before I went in, I saw an oncoming car. So I stopped and we both stopped, and I thought to myself, I'm going to need to reverse a bit before I then put my car into the correct bay. On reversing a bit, I turned to my right to check my rear view, and there was a car reversing out of its stationary, where it was, stationary. And I thought to myself, hang on a minute, if you're going to reverse and I'm wanting to reverse to get into this park, I need, I put on my horn, and I thought to myself,
can we just, let's come back to, what's the question, Kate? as opposed to what you thought and the rest of it.
Okay. So eventually we worked out he continued to reverse, hit my car. I looked at him.
At the point he hit your car, was your car stationary?
Yes.
Okay. Yep. He's responsible for hitting you.
Yep. We both pulled in, stopped the cars, exchanged details, and then because I was so shocked
Kate,
that the fact that he'd...
Kate, you haven't told us what the question is yet.
Who is responsible in the event that the series of events occurred?
But it's the last one that counts, Kate. You're in a car where you are entitled to be, and somebody reversed into you.
Yep.
Right. So that's the issue, is that you were waiting in a car parking, between two aisles in a car park, or in an aisle in a car park, where lots of people prop waiting for an opportunity, and somebody has backed into you.
And Kate, what's the problem? Is the insurance companies seeing this differently, are they?
No, when we both inspected the vehicle, I was so shocked and in a state of disbelief that I checked the front of the car.
Kate, I'm sorry. We want to get to a few more other calls. Did the insurance... So the insurance companies are settling this. Is it falling in your favour?
No, there's no insurance involved. He's disputing my series of events versus his series of events. I've got the CCTV footage. However, they're not coming to the party. I just want to know...
No, my view would be you were stationary at the time that person reversed their car into you. And there's also almost an assumption that if you're reversing, you're liable, but go for your life. I think you're in the right.
Kate, thank you very much. Would the advice be to turn that over to the insurance company, David, to say, this is what happened...
But Justin, if it's a $500 fix and a $1,000 excess, why would you give it to the insurance company? Because then you get your no claim bonus is affected. It just gets worse. It really depends what's the cost of the fix, and you make a decision based on the economics.
David's in Preston. Hello, David.
Hello.
We've got you. Go ahead.
I spent $400 a few years ago, or a couple of years back, on some restaurant vouchers for my family, and the business has since gone bust, and they never got used. So I've emailed them and given them my details, banking details, and the details of the vouchers.
Can I ask, David, did you buy the vouchers as part of a book, so you got multiple vouchers for a fee? Or was it notionally you've prepaid to get a $400 credit at a particular restaurant?
Yes, the latter. Yes.
Okay, right. Then your claim is you make a claim on the liquidator.
Done that, and we're in some sort of weird email conversation where they've gone completely dark on me, and I just keep emailing them saying, should I just write this off? It's only $400. Obviously, I'm not going to spend money getting it.
No, but you're able to put in a proof of debt, David. I can't promise you'll get any money back, but you go to them and you say you want to put in a proof of debt.
David, thanks for calling in. Greg's in Gisborne. Go ahead, Greg. We've got you.
Oh, good day, Justin, David. I've got another elderly mum question.
Yep.
Simpler than the last one, I hope. It's a question about certified copies of documents. Just wondering if I can, I'm doing applications for residential care for her. I was just wondering if I can take copies of certified copies.
Yes.
Or do I have to
hang on. Let's get this right. You can, when you're using powers of attorney, you are able to have certified a copy of a certified copy. So you've got an original, then you've got a certified copy. You can get that certified copy copied and certified. Right? So if you can go and get someone to certify that the document they're certifying is a true certified copy of an original. Sounds messy, but it's a 2-level certification for powers of attorney allowed under the Powers of Attorney Act.
Greg, thank you very much for calling in. Lisa's in Bendigo. Hello, Lisa.
Oh, yes, hi. Justin and David. I just have a question about a deed of family arrangements.
Yes.
After my father passed, my mother became the life tenant under the deed. She was entitled to regular annual payment, which indexed to cost of living increases. And that deed also required certain family members who benefit from the working land to cover the maintenance of a home and property. Unfortunately, she's now passed, and I'm not sure if those obligations were fulfilled. So as one of her daughters, I would like to know, can those unpaid amounts now be claimed by her estate?
Yes.
They can.
Unless they're going... So let's say, I don't know, let's say I'm the person who's offered to pay $2,000 a month to your mum.
Yeah.
Then her estate can enforce that money to the extent that it hasn't been paid.
Okay, even if my dad passed away some time ago?
Well, I don't know what the deed of family arrangement says, Liz.
Yes,
if there was
right.
an obligation that was not fulfilled and it was for the benefit of person X, and particularly where it involves the payment of money, then you're able to say the money you were supposed to pay, you didn't pay for this period, it now needs to be taken into account.
Lisa, we appreciate the call. Alan's in Ferntree Gully. Good morning, Alan.
Oh, yes. Good morning. Thanks for taking my call. What my question is, it's just concerning my sister. She owns a fair bit of land, and sometime in the past, the government organisation to do off road construction, they had to remove a lot of dirt to fix up the road, and they offered to just truck in the dirt to her place because it's just across the road and a lot of hollows, so it'd be a win-win situation for both of them. So she accepted it. It was easy to fill up all the hollows, all this dirt, trucks of dirt for the road construction. And then she subsequently found out from the local council that the dirt has got the dirt is contamination. It's got contaminants in it, and it has to be removed. The council wants to remove the dirt because it's contaminated. And I was speaking to a friend of mine, and he was in a similar situation, and he told me that, no, the organisation that was responsible for constructing the road and digging up the dirt and then trucking the dirt over to her place and dumping it there, they're actually still responsible for the dirt because it's contaminated. So I'm just asking David on the legality of that. Is my friend correct that the organisation responsible for constructing the road...
There's a couple of issues there, Alan. From the point of view, my view is the work will have been done for the council. So my starting point would be go back to the council and say, what was your obligation with the road crew? Were they obliged to appropriately dispose of the land, the contaminated soil? And if they were, then your argument is that they haven't because they put it in an inappropriate place. So get the council to lean on the contractor. Now, what you then do is you're then arguing about your sister's position regarding the contractor, and that argument is that your sister is going to be relying on an implied representation that there was nothing wrong with the soil that was being contaminated, was being dropped. And that'll depend on where it was going. So if you're putting it in farmland, there's an expectation it will have no adverse effect. So I would be talking to the council first and see if you can get them to make the contractor appropriately dispose of as opposed to just dispose of.
Alan, thank you. We've got time for one more, surely. Amanda's in Forest Hill. Hello, Amanda.
Thank you, Justin. Good morning, David. David, King's birthday, a pizza delivery guy backed into our car parked in our street, and he has accepted, he says he didn't realise he'd hit it, but he's accepted he has hit it. Yes. With a ute with a metal tray. So it's done a lovely big slice in the front panel. Yep. But my insurance company haven't been able to get him to provide them, and he didn't provide it to me, with his address and registration details. Is there anything I can do, or do I just need to leave it to the insurance company? Because at the moment they want me to pay the excess.
Well, you pay the excess because you're making a claim.
Correct.
If you want, then you're going to have to go and find the registration number in order to, and the name, to get your insurance company to let you off the excess. So it's up to you.
So they won't do that for me?
No, they have no obligation to do that.
So
no, you're making a claim on the insurer.
Yeah, but it would say in Amanda's policy, I'm guessing, that she needs to be able to provide the name of the person And
she needs to be able to prove it's not her fault.
But at least the registration of the person.
Well,
and
I
then
don't know
they
what
take
their
it
policy will say, but you and I are in a car accident. I make a claim alleging you've done something wrong. I need to provide your name and details of the registration of the vehicle so that the insurance company has sufficient information to take it further.
Well, let me assure you.
Sorry, Amanda.
Let me assure you, if you and I are in a crash, it's your fault.
Understood.
As a lawyer, you should know that.
Indeed.
Thank you very much. David Whiting, Melbourne solicitor. He is here every Tuesday. He'll be back with us next week.